Mr. Narwhal. Good morning.
May it please the Court, my name is Bill Narwhal. I represent the plaintiffs, Joseph Iannacchino and Victor Marchese. With me at counsel table is Kristen Fritz, my co-counsel. We are here on an appeal of a Rule 64 report. That report was made based on a motion for judgment on the pleadings. The importance of that is that the factual allegations of our complaint for purposes of this appeal must be taken as true. I want to just highlight a couple of those allegations and then get right to the issue of where is the loss and talk about that specifically. The allegations, and I think I can summarize our entire complaint in about 5 sentences. The plaintiffs here are Massachusetts residents who currently own certain Ford vehicles which have defective door latch systems. 2, the door latch systems do not comply with Ford's internal standards or with the Federal Motor Vehicle Safety Standards, specifically 206. That's our complaint at paragraphs 25 and 27. 3, Ford knew of this defect from its own testing, stated in its own internal documents that the door latch assemblies were not compliant with its own standards and federal safety standards. That's our complaint at paragraphs 50 and 59. 4, in March of 2000, and I really want to emphasize this because I think this gets lost in the shuffle here, Ford determined itself that it needed to undertake a recall because of these door latch systems. At the last minute, and this is at paragraphs 58 to 74, Ford changed its mind and, to use the trial court's expression, covered up the defect and the need for a recall when it realized the expense of replacing.
Well, that's not the trial court's expression. That's the trial court summarizing your allegations.
But that is
no
there.
Findings of fact by the trial court
Right.
here.
And if you, Your Honor, if you will look at paragraphs 58 to 74 of our complaint, we cite.
That's correct. It's just your
I agree.
allegations.
I
There are no
agree.
findings of fact here.
I agree that's not a finding of fact.
If you
I'm
look
simply
at your
using their
complaint, you look at your complaint, and I agree, and they agree, of course, your adversaries agree, you've got to take the whole thing as true. We've got some serious defects on all these Ford vehicles in which Ford has engaged in a massive cover-up to avoid having to recall the vehicles.
Correct, Your Honor.
So we come then to the hard issue,
Correct.
the injury.
And let's talk about the injury.
And we've, as you know, this court is split on that.
I think it may be in certain cases, Your Honor. I don't think it need be in this case, and let me tell you why. I would tell you that however this court or anyone reads Liardi, Aspinall, and Hirschnell, in this particular case, I satisfy all of those cases. In fact, I think this, and I don't want to make this too simplistic, I think this is an easy case, and let me tell you why. The plaintiffs purchased and currently own a vehicle that does not comply with the federal motor safety standards. It is against the law for Ford to sell a vehicle that does not comply with those standards. That's 1. 2, plaintiffs have suffered a diminution in the value of their vehicles. That is what we plead. We don't have to prove that at this point. We have the right to go to trial and put on expert testimony.
So if I bought one of these cars on a private sale, or even from a used car dealer, 93A being what it is, the seller would have to tell me, I want to tell you that this thing has door locks that are defective. And the first thing I would say, of course, would be, well, how much is it going to cost to fix these? And they would say $500. Okay, take it off the price of the car.
Correct, Your Honor.
Yeah.
And that's what our expert would tell you, that the $650 cost of replacing 2 door handles would either be the cost of repair, which is I'm going to get to next, because we can look at this either way. It's either the cost of repair. What does it cost me to have a compliant vehicle?
So have any of the plaintiffs actually done that?
None of these plaintiffs have done that, Your Honor.
So no one has repaired this?
That is correct, Your Honor.
Defect that's been there for 10 years?
That is correct, Your Honor.
Why didn't you get one plaintiff to fix the door handles?
Have they tried to sell their cars?
No, Your Honor, because those are not people in our class.
I understand that,
Right.
but when Justice
No,
Gainey
neither
gave
of
you
our
the
plaintiffs-
hypothetical, so they haven't as yet lost any value, because they may never sell it, correct?
No, Your Honor, I believe that as they currently own the vehicle today, if you were going to assess the value of that vehicle today as they own it, just like a property contamination case, when you live in the house and your property has been contaminated, it's diminished.
Have an obligation to fix the contamination.
Right, and I think that what Ford has is an obligation under federal law to fix the door handle.
Well, if you have a motor vehicle accident, you're not obligated to fix the car before you can sue for property damage.
Exactly, Your Honor. My point is going to be that we could have two kinds of people here. We could have those who did repair and come into court and say, I want reimbursement. I want my $650 back. I have another group of people who said, I haven't spent that money yet, but I need to spend it to make it compliant. There is no logical distinction between those two groups of people. The fact that this person took money out of their wallet and bought the door latch doesn't make them any different than the person who says, I'd like the money first before I go and do it. There are lots of reasons why people make that choice.
Or I want the money and I'm not going to do it.
Or I can make that choice as well. But the point is, the question is you look at the plaintiff standing there today, do they have less than? Do they have, as this court said in Hirschenau, a loss, economic or non-economic? And that is clearly an economic loss. I have a vehicle when valued, and this is what the court in Florida said, it's common sense. When you have something that doesn't comply with federal motor vehicle safety standards, it's worth less. And that, to me, is an issue for the trial court on a full evidentiary presentation. We have pled.
Is there any question here that if one of the plaintiffs had, in fact, replaced one of these door handles, that they would have been entitled to the $650?
See, I understand Ford to be arguing if one of these plaintiffs had, in fact, redone it, and they had taken the $650 out of their pocket and paid for the door handle, they would be a perfectly fine plaintiff and they would have a claim. And my point is there's no distinction between that person and the person who says, I haven't done it yet, but I would like that money so that I can do so, or as Your Honor points out, I can do something else with it. But let me talk about a couple other things, because I think there are other issues here as well. When we talk about a loss, economic or non-economic, which is the last sentence of the Hirschenau opinion, plaintiffs under federal law were entitled in March of 2000 to a notice. And they're entitled to that under Commonwealth law, under 940 CMR 5.035, which are the Attorney General regulations, to a notice that they had a defective, non-compliant vehicle. There's no question about that. That's a matter of law. That is a loss. They were entitled to be told by Ford that they had a non-compliant vehicle that was defective. That is a loss. There is no question that that is a loss. They were entitled under federal law. Your Honor, you're looking quizzical at me.
Well, I guess I find it's a intellectual loss, but just not getting the notice that they had a defective vehicle in terms of Hirschenau or.
Let me explain why, Your Honor.
law?
Let me explain what I'm saying, because I'm going to get to the next point, which I think is even more compelling. But let me just stick with that point, which is under 49 U.S.C. 130118, they had the right, and we cite that provision in our complaint, they had the right to receive a notice from Ford, and so did NHTSA also had the same right to get that notice, that you have a defective vehicle.
Mr. Narwhal, doesn't that go to the point that we at least wrestled with in Hirschenau, which is that you are essentially turning any violation of a federal statute or regulation of any kind into a form of loss cognizable under 93A?
No, because I think the difference in this case, Your Honor, is that when I get that notice that I'm entitled to get, 99.999% of my class doesn't know they have defective door handles. That's the fact of life. And when they get that...
99.99% of people in Hirschenau probably didn't know.
But when they get that notice, and they're a current owner of the vehicle, they have a choice. They have an opportunity now to say,
I
want to
understand
fix it.
that, but that's still not, at least for the Hirschenau point, I mean, you may have, I'm not addressing your other points,
Right.
but essentially what you've done is point out a violation of some statute or regulation.
But unlike Hirschenau, which took a transitory one-day contract and looked backwards, I'm sitting here today. I have a right to be able to make a choice as an owner that the manufacturer of the car has told me, by the way, you have a defective door latch that under certain circumstances will open in a side impact. I've lost the right.
Well, yes, but under the Hirschenauer analysis, if something happened in Hirschenauer, for example, there was an accident, if something happened here and your clients were involved in an accident where they were harmed because the door handle didn't work or operated in some defective way, then, at least for those purposes, there's an injury.
And let me
Is it essential to your case?
No, it's not. And I was trying to go through the list. But let me go to the next point, because I think this might cement the point I was trying to make. In addition to that notice, under federal law, once, in the same statute that I just cited, 30118, 49 U.S.C., once it is determined by Ford that there is either a defect or that it is non-compliant with the federal motor vehicle safety standards, they must issue a recall and repair. That is clearly a loss. I clearly lost that right to have my vehicle repaired in March of 2000.
Well, isn't the argument this, though, that if Ford had complied with this law, you wouldn't be here?
Probably not.
Because
Your Honor.
you wouldn't be
Probably
able to
not.
pursue this.
That's correct.
Right,
But
so if
now,
they had
now having not notified them, NHTSA not having ordered the recall, and having millions of people with those door latch systems in their car, we are here. And that's why we're here, because that didn't happen. That is the point of the cover-up. That is the point of saying, when you don't give that notice, I have the right to be here and to challenge that activity. And again, I get back to, we're here on the allegations of our complaint. This very conduct is laid out in the complaint. It's factually laid out and must be taken as true. I have obviously the obligation to prove that.
Obviously, the judge in the Superior Court concluded otherwise, correct?
But, Your Honor, let me talk about that, because I think that it is, to me, the Superior Court decision is irreconcilable, and I point you to pages 5 and 7 of that decision. On page 5, when the Superior Court judge here is dealing with the 93A claim, he says, middle of the page, similarly here, no plaintiff alleges that he has been in an accident where the door latch has failed or otherwise suffered any actual damage. Plaintiffs allege only the rather speculative and premature damages stated in paragraph 81, which are the things I've talked about, repair, diminution, notice, and so on.
Which he refers back to.
Right. But then you go to page 7 of his decision on the implied warranty, and he says, I'm sorry, page 8, I guess it is, and I'm looking at the first full paragraph, second sentence. Nevertheless, the reference language of the SJC indicates that plaintiff's injuries have already been suffered at the time of purchases and indicate the damages need not have been actually incurred when the complaint is filed. And so I've got on the warranty claim.
Well, that's what the judge is in essence asking us to sort out. He's saying under the 93A case law, this is what this holds, and then under essentially Johnson Insulation, which is an implied warranty case. Now, obviously, they are two very different causes of action, and the same conduct, you will agree with me, may constitute the basis for a cause of action under one route, whereas it doesn't under another, correct?
I agree with that, Your Honor.
So the fact that the judge reaches a different conclusion for the breach of an implied warranty doesn't necessarily cause me to say that he's being inconsistent. I think what he's been doing is trying to be very careful to follow SJC precedent.
And I would agree with that, but in this particular case, the inconsistency, which is the fact of injury.
No, it's because in Johnson Insulation, we said at the moment of purchase for implied warranty purposes.
But what I think Johnson Insulation also says is, if at the time of purchase you have not fully expended the monies necessary to repair.
For implied warranty purposes.
Right. That we will conclude that your injury is current, that the expense of money is later. And I think that the exact same analysis ought to apply in 93.
Well, it might or it might not. But all that the judge was doing was saying, this is what Hirschenauer leads me to, and this is what Johnson.
And my point, Your Honor, is that this is not a Hirschenauer case, because as I sit here today, Hirschenauer looked backward at a contract that had been completed that had no impact, or so the court, at least the majority felt, had no impact on that individual. I am sitting here today, my clients are sitting here today with a vehicle that is non-compliant, that costs $650 to repair, They did not get their notice. They did not get their recall. I am sitting in a much different position than the individual in Hirschenau. I think this is a much easier case. I think the concern that the court was addressing in Hirschenau and the tension in Hirschenau and Aspinall is much more apparent in these contract cases than it is in a products case like this one, where I'm currently owning an unsafe and defective product. And I see my time is up, Your Honor.
Thank you, Mr. Narwold. Mr. Boyle?
Thank you, Chief Justice. May it please the Court. With me at council table is Mel Schwing, my colleague, and also Tom Elcock. Mr. Narwold said that the plaintiffs are here on the allegations of their complaint, and since that is absolutely right, I want to review those allegations very carefully because I think they're
Could I ask you,
there are some
please?
misconceptions.
Could I ask you, please? Hasn't the non-compliance by your client affected the plaintiffs because they have a car with less than they would have had if it met all the safety standards?
They have a theory of unmerchantability, if you will, based upon this abstract allegation that the vehicles have an issue under FMVSS 206.
Well, is there any question that the cars don't meet the safety standards? Are you questioning
Okay,
that?
let me go through those allegations.
But wait,
Justice
I
Conlon.
thought this was agreed fact.
No.
I'm sorry.
This is allegations.
Okay, these are allegations, but we have to take
But
the, I'm sorry, we have to
let
take
me-
the
let me
allegations
fo-
as true.
No, let me focus on those allegations, Justice Cowan, because I think there's been a casual misdescription. If you look at the complaint, what the plaintiffs say is that the source of the defect is in Ford's choice to certify the vehicle's compliance with FMVSS 206 using not what the plaintiffs call a preferred methodology, which is Society of Automotive Engineers J839, but rather using what the plaintiffs call a 30-year-old GM test. And it's in that choice that plaintiffs say that the defect can be found. Now, here's the problem. The complaint says Ford used the GM test when it discovered the problem in 2000. It used the GM test. The plaintiffs say that in their complaint. At argument in front of the trial court, in order to avoid the primary position we advanced in the trial court, which was a primary jurisdiction referral to the National Highway Traffic Safety Administration to resolve this federal question, the plaintiff said, well, Your Honor, we don't disagree that the GM test is an approved test. That is a proper basis for certifying the vehicle's compliance with FMVSS 206. They went on to raise questions about whether Ford, in fact, had used this GM test. But I would submit, Your Honors, that the complaint takes care of that. The complaint at paragraph 69 says flat out, in 2000, Ford went back and looked at the vehicles, used the GM test to verify the vehicle's compliance with FMVSS 206. And so I think at bottom what we're looking at, Your Honor, is an allegation that the vehicles are defective because regardless of what federal law supplies, Massachusetts law requires more in the way of door latch integrity than is suggested by one of the alternative tests that the federal government has supplied.
Do you mean,
for door
are
latch.
you saying that if you accept the allegations of the complaint as true, there is no injury alleged?
Accepting the allegations as true, these plaintiffs are unable to point to any respect in which their lives have changed, any adverse effect at all. And
No,
I'm not
I
talking
appreciate
just
that.
about
I mean, I assume you're not talking about the fact that let's put to one side the fact that they haven't yet incurred $650.
I'll put that to the side. They
Yeah.
haven't even said that they can't use the vehicles in the way that they intended to use the vehicles. There's no respect in which their use of these vehicles has been compromised, allegedly.
I thought you were saying just now that if you read these allegations and you take into account what was said at the argument before Judge Fremont-Smith, that in fact they haven't even said there was anything improper that Ford has done. Are you saying that or not?
What I'm saying is that the species of defect theory we're dealing with here is not, as the counsel described, complete disregard for federal motor vehicle safety standards. It is an allegation that Ford, that under state law, that Ford, in deciding to use the GM test to recertify these vehicles' compliance with Federal Motor Vehicle Safety Standard 206, a test that plaintiffs have conceded was approved by NHTSA,
Where do they
Where in
concede,
your
where do they
brief,
concede?
where in your
That is
brief
not
do you
enough
make,
strength
where in
under
your brief do you
Massachusetts.
make this argument?
sorry?
Where in your brief do you make this argument?
It's in the description of the facts, and it's in the appendix, Your Honor.
Yeah, but it's not in your argument
Well,
part.
Understood, but in
I
candor, I
take-
have to come to the court and...
Let me see if I understand you. The gist, as I understood it, of Mr. Narwhal's argument was they violated federal law. That has caused us an injury because they violated federal law, because in a variety of different ways. Judge Fremont Smith focused, and they claim, by the way, that the GM test, they allege that the GM test was never used before and so on and so forth.
They
correct?
don't allege that, but that's what counsel said here today. That's right.
I was just looking at Judge Fremont Smith's opinion. I take it that your position is that you did use the GM test, correct?
That is correct.
And that is an acceptable way under federal law to
Plaintiffs
test.
conceded as an acceptable way, that is an approved test, and that was their basis for convincing the trial court not to make a referral to the National Highway Traffic Safety Administration. But let me accept at face value the allegations as they've been described today, because I think the court granted review for a reason here to resolve some issues associated with the injury requirement. And the point I want to make, and this is our major submission here, is that it is not enough, when you have a consumer product at least, it is not enough to complain about the potential for a future failure in performance when the vehicles or the product at issue has met all of the demands that the consumer has placed on it.
But
But
they're
that's a
saying
question.
they're saying it's defective. They're saying it fails to meet the warranty of merchantability. And if you take that allegation as true, that it fails to meet the warranty of merchantability, the fact that they haven't paid the $650 to replace it is irrelevant, isn't it?
I think here's the point. They have a contention that these vehicles are unmerchantable because of their capacity or a certain kind of performance.
Because they violate federal standards.
Well, okay, we referenced my earlier discussion on that point, but let's accept that as a given for the time being. The point here is that the door latches could come loose in the future in certain kinds of collisions. That's the thesis here. And I would agree that they could meet the injury requirement, the requirement of loss for purposes of the implied warranty of merchantability, if they could say anything about whether that potential defect, that potential for future failure, has affected them in some way. If they said that they don't drive the vehicles the way they intended to drive them, they only go at 50 miles an hour.
But the merchantability of warrantability doesn't require a collapse of the product, does
Well,
it?
what it
I mean,
requires-
if they had paid the $650 to replace the handles, would you be here today?
I would concede that if they had incurred that expense to either inspect or repair the latches, that would be injury that would qualify them to get into court. They
I
haven't done
take it,
that.
Mr.
And
Boyle,
indeed, the vehicles being now 10 years old, almost through their entire useful lives, it's quite speculative to say that because they intend or they say they will incur repair costs in the future, that is a basis for credit.
So the fact that they have not paid the $650 does not mean that they don't have a compensable loss.
It is, if you're going to rely on the incurrence of repair costs to establish a loss, then you have to incur the repair costs.
That's what I mean. That's why I keep getting back. If there's no, if whatever the allegation is, if in fact there's, it seems to me, and maybe I'm just missing the point here, that unless we turn every violation of a federal standard, because this is on a judgment on the pleadings, which is the issue we precisely addressed in Hirschenauer, and I understand, and I'd like you to address Mr. Narwhal's point, that in a sense, Hirschenauer was easier because the contract had been completed. At least that was the theory. So we knew that as to that group of plaintiffs, they would incur no loss.
Here we have vehicles that are basically fully consumed. They've
Well,
been
is
on the
there
road for
evidence,
10 years without
is there
any
anything that establishes that we know, A, how long these plaintiffs have owned the cars, and B, what is considered in the industry, the life of the car?
There's nothing in the record to that effect.
So how do
And the
we know
complaint-
these plaintiffs could own cars for 20 years?
Because you have to
That is
decide
true,
that there's an injury if you violated some statute, correct?
These kinds of claims are not new, Justice Cowan. They've been rejected around the country for three primary reasons. The first is that the theory that a potential for future failure, whether it's due to what plaintiffs describe as a design defect or a regulatory violation, the idea that that is enough to get into court is defective because it can be said about virtually any complex consumer product. The fact is, if you look at the judicial annals, for every instance where a complex product has resulted in a malfunction and caused injury, you have a lawsuit like this one in waiting, a no present injury lawsuit. The sheer breadth of the theory is reason enough to reject it.
But that's not, is that really the theory of their case? They're talking about a UCC problem, a breach of the warranty of merchantability. You don't have to have a collapse of the product.
Well, what UCC requires, and I think it's 27141, requires a loss resulting in the ordinary course of events, or some language very much like that, in order to bring a breach of the implied warranty of merchantability. And what courts have found, and this is the second point that's been very influential in rejecting these claims, courts have found the notion of a loss here to be quite speculative indeed. To try to value the potential for failure and what the potential for failure has done to the value of the vehicle and tease it apart from the failure potential of all the other parts in a complex product is very, very difficult indeed. It's complete guesswork, and it's particularly speculative inasmuch as that loss may never be realized, a point that's punctuated by these plaintiffs and their 10-year-old vehicles.
And yet you say, I mean, these are handles we're talking about, and yet you say that if they'd gone and repaired these, then
Well, I think if they'd gone and repaired these, Your Honor,
they would have incurred
it would suggest that the issue was perceived as serious enough by these consumers
So it's easy to
merit
calculate.
judicial attention.
Well, it's
But they
easy to
wouldn't have
calculate
to.
what the repair cost
I'm
is.
sorry?
Isn't it? It's easy to calculate what the repair cost. There's no uncertainty or very little uncertainty about that.
But the question is whether there's a loss. And if I say next year I expect to be distressed emotionally, that doesn't mean I can recover currently for that emotional distress. And if I say analogously that I expect to incur repair costs in the future, that doesn't establish a present loss.
Well, go ahead and finish your answer.
Well, my point was the antecedent question is whether there's a loss here. In the product world, that is measured by the performance that the product is delivering. And here, plaintiffs are unable to say that their latches have ever malfunctioned, that they've ever done anything except upon the command of their own hands. They don't drive the vehicles differently at all. They don't curtail their use at
And
all.
they
They're
don't
fully
point to
consuming
anybody else who's done that.
I'm sorry,
And
Chief
they don't point to anybody else who's done that. Take, for example, a tire blowout, right? You have a tire blowout somewhere. And then what follows in the wake of that is a determination in that case that that was because of a design defect, and then you may piggyback onto that a class action sometimes.
Well, sometimes, but not usually. There,
Not
the
usually.
jury looks
Here,
at the question whether
they've
this.
simply said there's a violation of some federal regulation.
Well, yes and no.
Can
Look,
I-
what if, I own one of these cars, and I'm a smart person. I meet Mr. Narwhal at a cocktail party, and he tells me about this. And I say, oh, gee whiz, I got a car here where that might pop. And then I decide to sell the car. Am I under a duty to explain to the purchaser that he or she may have to shell out $650 to fix this, or do I keep silent?
It's a good question. I don't know the answer to that under Massachusetts law. Usually the disclosure duties
would depend a
are
little
imposed
bit
upon
to what
those who are
the-
in a trade or business.
Wouldn't it depend a little bit on the basis of that was? In other words, if somebody at a cocktail party says, I think that if, the safety locks of these things don't work, not because mine didn't work or I can point to one that didn't work.
If they, I will say this, that if they tried to sell and disclosed the defect and couldn't sell as a result or experienced a lost sale, they could take that injury to court.
What if you had what Mr. Narwhal said, that you actually, let's just say that you accept what he alleges is true, that Ford was going to do a recall and decided not to. Let's say Ford did do a recall and said there's a problem with these door latches and you're entitled to recover. Do you think that would somebody, or let's say the federal government said you need to do a recall, but they didn't. Would somebody in that instance, so there's been some determination there really is a problem.
Really
here.
is a defect.
Yeah, but it hasn't come to pass yet. People are still driving their cars, no problem. Would those people have no cause of action?
They might have no damages.
They could go to the National Highway.
Yeah, here's the third reason why this theory of injury is proved so unpopular in courts, and that is that when you address these defect questions on a very abstract level outside the context of a specific product failure, you get juries and courts outside their institutional area of competence, and when there's no need to, because of course, as Your Honor pointed out, there is the National Highway Traffic Safety Administration. Plaintiffs specifically plead that if NHTSA found there were a defect, they would order a recall. And so, and just to finish the answer to the question, this institutional competence point is important because if a jury or court gets it wrong in one of these no present injury class actions, says, oh yes, they're all defective in an abstract sense and orders some sort of retrofit or repair remedy or money damages, that can create crushing liability for their manufacturer. If they get it wrong the other way and say, in fact, there is no defect in an abstract sense, that point could collaterally stop future plaintiffs who are members of that class if they present a personal injury. So there's a reason why these theories have proved so unpopular and why the courts have preferred to defer to
I have a
administrative
very basic question, Madam Chief Justice.
Sure.
I'm afraid I still don't understand. I'm sure it's my shortcoming, but it's judgment on the pleading, so we have to take the plaintiff's factual allegations as true. You agree? Or you don't agree with it?
I agree with that. And
Okay.
I would say inclusive of what plaintiff's counsel said in the oral argument before the trial court at Appendix 39 to 41, because there they interpreted their complaint to concede that the GM test was an approved test, the test that Ford used.
The factual allegations change based on oral argument? Is that what you're telling me?
I'm just saying we have to read the complaint the way the plaintiff's counsel read the complaint at the trial court.
Say that in the complaint they allege that the vehicle has a defective door latch and that the door latch doesn't comply with Ford or federal standards.
And the complaint, when you pull it apart, it says that the reason there's not compliance is that Ford used this 30-year-old GM test as opposed to the preferred J839 test. And that's all the complaint says. It says Ford used that GM test. And so at argument, plaintiff's counsel, to avoid the referral to NHTSA, said the GM test is approved. There's no dispute about that. And so I think effectively plaintiffs have pleaded themselves out of court, at least to the extent their defect theory is considered as anything other than that Massachusetts law requires more than what the GM test supplies. I think that's really what we're dealing with here, and that makes plaintiff's defect allegations very much like
You're
the
saying that
run-of-the-mill defect
you're saying that
allegations.
if we look very closely at the allegations, we will see that they say that Ford used an old, outdated test and that the door latch part met the current GM test. Is that what you're saying?
I think if you look at the complaint,
We'll see
you
that.
will see that, and you
Okay.
certainly see that at Appendix 39 to 41. By the way, it's kind of ironic that they refer to the GM test as a 30-year-old test. What plaintiffs describe as the preferred test, J839, is older than that. So I'm not sure I understand the point. Thank you, Your Honor.
Thank you, Mr. Boyle.